I'm online. Good afternoon, good evening. Thank you for making your way through the weather and the traffic on the road to be here this evening for St.Peters on Willis social justice group Red Tape Hui. So I'm just here to initially welcome you and show you where our facilities are and what to do in the event of serious natural disasters or other. So first of all, definitely welcome to you, and you're in St.Peters on Willis, St.Peters Anglican Church Te Aro, which has a long history of social justice, and our facilities are that if you go down the stairs there, walk across over here, you will find the toilets. So that's an important thing to know. If you need any help, we've got assistants around who can assist you. And in the event of an earthquake, well, the building is still here after over a century, but we do the standard stop, drop and cover and wait for advice from those in charge here to assist us after the event. If there's a fire, there's the door that you came in is where you exit, or you can exit that way, but preferably the door there, and the place that we assemble is across the road, or immediately across the road. And I think I've covered it all. So I'd now like to, in addition to hand over to Reverend Jean Malcolm to get us started. Thank you.
Tēnā rā tātou katoa, ngā mihi atu ki a koutou. Nau mai haere mai ki tēnei whare karakia, Pita Tapu. Welcome tonight to this hui, welcome to St. Peters, welcome to this long history of caring about our community. I'm going to begin with some karakia. Whether you are a praying person or not, we invite you to be still, to be aware of the life that is within us and between us and beyond us. Kia inoi tātou. E te atua, te kaihanga o te ao, te kai aroha o ngā mea katoa. E arohaina mātou e koe, e hia ana koe ki a mātou, ki a tiaki tētahi ki tētahi. Holy God, creator of the world, lover of all things, you love us and long for us to care for one another. Kua tae mai mātou i tēnei pō ki te whakarongo, me te urupare ki ngā wero, ki te tiaki i tō tātou whenua, me tō tātou hāpori. We come tonight to listen and to respond to the challenges, to care for our land and our community. Manaaki tia tō tātou huihuinga i tēnei pō, me homai ki a mātou te maia, ki te whakarongo pai, ki te kōrero aroha, ki te mahi ai mō te oranga o te katoa. Bless our gathering tonight and give us courage to listen well, to speak compassionately, and to work together for the good of all. Amen. Amen.
Te hei mori ora, ina mana, ina reo, ina marawaka. Nau mai haere mai, tēnā koutou, tēnā koutou, tēnā koutou katoa. I'm Greg O'Connor. I'm here as a friend of Gail's, as her MP, being the MP for Rahariu, as an assistant speaker, and take a pick of any one of those. But I have a role here tonight to be the MC. This is a non-sitting parliamentary week, which means that obviously there's nothing going on in the House. So I'm looking forward to what I'm sure will be a much easier job tonight of these fine gentlemen who are going to take us through the Regulatory Standards Bill from a very sensible and well-informed base, which is sometimes lacking in my day job down in Parliament. Look, I think it's it's great that we're actually having, and congratulations, Gail, for you and your team. The fact that we're having this debate here, there's a lot happening around here. I know there's meals being given out. There's a lot of other activity happening around here. So I think it's very apt that we would be having this debate here tonight. Because there are real life, real world consequences for everything that we do. I think that's a very good context for what we're going to be talking about tonight. So these three speakers are going to be taking us through David Seymour's or their views or various aspects around the Regulatory Standards Bill. One thing before I introduce our first speaker, I'll say that part of my role as a local MP, you may be aware that there are a lot of wind farms out in the Hari Valley, and there was a lot of debate out there around the installation of the wind farm there. And it's brought me to the realisation that everyone hates regulation, everyone hates the Resource Management Act until it becomes their best friend. And when it becomes their best friend, then they will look to every aspect of it to advantage themselves into that position. And against that background tonight, we now will be debating the Regulatory Standards Bill. Our first speaker tonight will be Bryce Wilkinson. Bryce, you knew that you were speaking first, Bryce. Bryce, I've known Bryce for some time, in another iteration from when he was the Business Roundtable, which of course is now has a new iteration, which has become, of course, the New Zealand Initiative. Bryce, I think you're one of these. Looking at your CV, you are an academic. You have worked in some of the institutions, including you've been a fellow at Harvard, Harkness Fellow at Harvard University. So to be able to bring your experience and your presence and your long-term, I suppose, interest in politics to public policy, but also politics. Because I know there's the two are not always that are not. Sometimes they're good bedfellows, sometimes they're not. But anyway, Bryce, you've got you for 10 minutes to discuss your topic of choice, and look forward to hearing from you. So whether you'd like to speak.
That's good, yeah. Good evening, and thank you very much, Greg, and thank you to Gail in particular for organising this. I particularly appreciate, actually, the Social Justice Group for providing the opportunity to have this discussion, because it's all too hard to have non-polarising discussions this time. And as soon as I saw the other speakers, I respect them both, and I think this is a really good opportunity. It should be a good session. Now, we have yet to see the bill, but the Ministry of Regulation's discussion document has set out its proposed principles, so we do have something to work on. And particularly since we're at a church today, why don't we bring a Christian perspective to bear on them? Christian principles, after all, are relevant to all aspects of human affairs, including this one. Well, I'm far from being a good student of the Bible, but as we all know, it abounds with advice and guidance about good conduct. And this bill is about getting better conduct out of Parliament. So let me start with a biblical story from Exodus 18. Moses was overwhelmed. Each day he sat alone, judging countless disputes amongst the Israelites. Observing this, Jethro, his father-in-law, gave him wise advice. He urged Moses to appoint trustworthy leaders to administer justice transparently and guided by clear laws known to all. Difficult cases would still reach Moses, but everyday matters could be resolved fairly and openly by others. And this story illustrates the biblical value placed on good lawmaking. Laws should be transparent, understandable, and just. And the proposed principles of the Regulatory Responsibilities Bill are aligned with Jethro's advice. The first provision in its rule of law principle says the law should be clear and accessible, and its good lawmaking principles and the proposed measures provide for fair process. But first of all, what is the bill proposed? To understand that, you need to know what it actually says. After all, as Proverbs 18-13 wisely observes, to answer before listening is folly. It is a simple transparency measure. It aims to better inform Parliament and the public about regulative proposals. Its premise is that sunlight is a useful disinfectant. This premise might remind you of Ephesians 5:13, but everything exposed by the light becomes visible, and everything that is illuminated becomes a light. Well, the foreshadowed bill has 2 steps. Step 1 requires ministers to certify whether laws and regulations are consistent with the long recognised fundamental law and economic principles. That's step 1. Step 2 provides a modicum of public discipline by establishing a board that can issue public, non-binding opinions on the consistency of a measure with those principles. And that is it. The proposed board verdict dispenses sunlight, but otherwise it changes nothing. The law and regulation can stay in place or be passed by Parliament regardless. Parliament is informed, but it is not bound. Parliament is as free as before to pass any law or regulation it wishes. And I cannot emphasise this critical point enough. The proposal fully preserves parliamentary sovereignty. A future government is free to take a different path. It is free to draw the curtains, to keep out the sun. It will have its own Minister of Regulation. It can abolish or amend the Act. It can replace the principles. It can replace the guidance. It can replace or abolish the board. And it will, if the critics are right. But if they are right, why are they so concerned? The measure will not survive the next change in government. Well, what are the key principles which are so controversial? And what are their biblical foundations, since we're in a church? The principles regarding individual dignity and property rights form the basis of the English legal system and have emerged from battles for individual rights dating back to Magna Carta and beyond. For decades now, successive versions of the legal committee's guidelines have set out New Zealand's fundamental constitutional values and principles. In the 2021 version, which is the last one, this is done in Chapter 4. Chapter 4 comprises 10 parts. The last part is clear that Parliament must, yes, it uses the word must, comply with these principles unless, they're not absolute, unless clear and unambiguous language that a departure is intended. So the principles aren't absolutes, but in prominent place in Chapter 4 are the principles of the rule of law, state protection for the dignity of the individual, a presumption in favour of liberty, and respect for the peaceful enjoyment of one's property. At one point, the guidelines even emphatically state that protection of property is one of the fundamental values of a liberal society. And the Bible actually gives us a powerful cautionary tale about property rights. In Kings 21, King Ahab coveted Naboth's ancestral vineyard, but Naboth refused to sell, saying, "The Lord forbid that I should give you the inheritance of my ancestors." Queen Jezebel arranged false accusations against Naboth, leading to his death in order to seize his property. The prophet Elijah later condemned the action. Even kings should not be above the law. And indeed, King Charles I found this out the hard way. Divine right to rule had its limits. For those who, despite this and Magna Carta, think property rights only protect the powerful, think about the compensation of Maori land without compensation in the 19th century. Would any of you support that today? I doubt it. Doubt if anyone would. Think also of those who live in overcrowded, unhealthy houses today. Many think they will never be able to afford to buy their home. They are not rich, and they might be right. We do not have enough houses, though, because our laws make it too hard and too costly to build more, even if we own the land. The poor are often the ready victims of bad laws. When discussing equality before the law, Leviticus 19:15 instructs us, "Do not pervert justice. Do not show partiality to the poor, or favoritism to the rich. but judge your neighbour fairly. In my humble view, the proposed principle that all persons should be equal before the law accords with the Christian view that no one stands on anyone else's shoulders in the eyes of God. Responses to some of the critics' concerns. What are the concerns we're facing? I don't have time to go through them all. It's a long list. And do I know what points Bryce and Craig would most like to challenge me on, so I cannot anticipate them. But in the hope that it is helpful, my remaining remarks briefly respond to 4 criticisms. I'll number them as I go through. This list does not include the prior question of, is there a problem with the quality of regulations today? And I don't do so because I think it's widely accepted that it is. Even in the public service, they say that there is a problem that the quality is variable. Right, first, number 1 criticism, the criticism that lesser measures would suffice. Putting these principles into a statute is a step too far. Well, the seminal measures to improve regulatory quality have now been in place for over 30 years. The 1991 version of the Legislation Advisory Committee's guidelines was extensive, and it's been revised several times since. So have been Cabinet manual requirements, and they include a regulatory impact statement requirement of an economic nature, that the benefits to the community should be expected to exceed the costs. So these measures have been around a long time, and they've had the power of the Cabinet manual, but they're only complied with indifferently. So lesser measures, the ones that stand, don't go far enough, and more needs to be done. And the more thing in the bill is to take these principles and put them into a statute book, and then Parliament can hold the executive government to account more directly for not obeying one of its own statutes. So we do need to change. We've got to change things, and as Ecclesiastic 1.9 reminds us, what has been will be again, and what has been done will be it again, and there's nothing new under the sun. Well, this is a modest measure to do something new under the sun. Now, the reason, it's quite a long conversation as to why things aren't going to change, but in essence, a government which is pre-committed to a campaign promise is going to implement it. It has to. And as things come up, it needs to get things done, and some of the things it wants done are partisan, they always have to be, and some are really in the national interest. And governments have come to use urgency very commonly to push legislation through, and urgency often means not enough time for enough public discussion and scrutiny, not enough time even sometimes for the law draftsman to get it right. So there is a problem. Rulers need to be held to account, executive government needs to be held to account by Parliament, and we as voters hold Parliament to account. So this is about accountability through transparency. And in 2 Samuel 12, Nathan held King David to account by telling David a parable about an unconscionable abuse of power by a rich man over a poor man. At first, David did not recognize himself, but when he did, the example applied to him, he acknowledged his sin. And the price David paid for that sin was incomparably greater than the board's declaration of inconsistent with principles. We regard the price as pretty inhuman today. Second criticism I'm going to address, the criticism that the principles are incomplete, neglecting others equally or more important, such as the Treaty of Waitangi and distributive justice. The proposed measures are indeed incomplete. This is because they're not a written constitution for New Zealand. They're not about the separation of powers, the running of the courts, the Electoral Act, and democratic processes more generally. They are focused instead on the quality of laws and regulations as they affect the public at large. Now, critical functions of the government are to achieve peace and security through national defence and good and well-intentioned laws that protect all in their person and their legitimately owned property. Don't trespass is one example. The common law widely dictates limits to freedom to act that affect others, like noise and violence. But in some cases, government regulation might do a better job. So government does have the right to interfere and override common law freedoms. Governments have to infringe them to some degree. It must have the power to tax in order to provide the needed protections, and it needs to tax for public health and public work reasons and much else. But the use of government power must be principled if it is to be civil and peaceful. Recall Habakkuk 2.2, which reports that the Lord instructed, "Write down the revelation and make it plain on tablets so that a herald may run with it." People have to know what the law is. It needs to be plain. And that is why clarity about fundamental principles is very important. And the legislative guidelines do not include distributive justice as a fundamental principle. But it is true that Chapter 4 of the guidelines includes a statement that legislation should be consistent with the principles of the Treaty of Waitangi. But there's no clarity or guidance about what those principles are as they affect people's lives and daily interactions. The principle has been debated today that Maori never conceded sovereignty and that tikanga trumps Christian spirituality would appear to deny the rule of law as we have known it since 1840. Who can say what is lawful today under that interpretation of the principles? What's that? Not the judges, yeah. 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 But people saying what differently? Yeah. Okay, all right. Well, come up in question time.
We're hoping just to leave time for questions at the end.
Yeah.
And Bryce will be giving it 15 minutes, about 3 or 4 minutes at the end for questions.
Okay, thanks, Greg. Well, you come back to it. I do welcome questions. Right, consider Proverbs 11:14. Where there is no guidance, a people falls, but in abundance of counsellors there is safety. So good laws need proper consultation, wise deliberation and counsel, and clear disclosure. But we're not seeing enough of it. Some of you may be reminded of 1 Kings 12. King Rehoboam rejected the counsel of experienced advisors and instead followed his young friend's hasty advice. Harsh laws were imposed and the kingdom split apart. But if someone can identify what regulatory measures would pass the proposed enumerated principles and yet fail to accord with the treaty principles, the rest of us would have a concrete objection to focus our minds on. And if someone could do that, that would be very helpful. Number 3, the fear of chilling future governments. Opponents fear that the very existence of these requirements in the statute book will have a chilling effect on future governments. But why would it if the measure accords with the principles? And if it does not, would a chilling effect be desirable? Regardless, as I've already said, a future government can simply acknowledge inconsistencies, give a good or feeble reason for them as at present, and it can make Parliament pass the measure basking in its supporters' applause, more or less just as it can do now. Number 4, coming to an end, the fear of potential fiscal costs. The compensation principle means the government would have to look at compensating anyone if it took their property, like in the 19th century confiscations. And there's a fear that could be a very heavy cost on the fiscal purse. But if the measure is going to make people better off to a greater extent than the cost to others, then the ones who benefit can afford, in principle, to compensate the ones who would be losing and still be better off because the benefits outweigh the costs. So the principle is not necessarily that it's the taxpayer who pays for the compensation. If you're taking a bit of land out of the public estate and giving another group preferred access to it, the benefit pays principle of taxation means that the people who benefit from a measure should be the ones who think it's good and are prepared to pay for it. But if, however, the costs of a measure exceed the benefits and that makes government hesitate, well, that should be a good thing because you don't really want laws and regulations that make people worse off. So it's really important, and this is where the economics or the regulatory impact statement comes in, that costs and benefits are balanced. And according to Luke 14:28-30, Jesus taught that before starting to build a tower, one should be sure to count the cost. He who lays a foundation but cannot complete the task will be mocked by others. Conclusion. These are the reasons why I see the principles just to be a modest transparency measure. I believe that the fears about it are greatly exaggerated, but if they are right, the measure can be and will be overturned by the next change of government. Thank you for your attention, and I do welcome questions and perspectives made in a tolerant Christian spirit.
We've got time for a few questions now. Thanks very much, Bryce. And then we'll have a panel discussion, all three at the end. So
good.
Just bearing that in mind, if there are any, I know there are a couple of comments there earlier. Yes, Mr. Cunliffe.
Thanks. Dr. Wilkinson, it's great to have you here. Thank you very much for coming, and thank you for your very lucid exposition of the bill. I wonder if Clause 6, which goes to the protection of property rights from impairment, would, in your view, apply to economic rents where they are embedded in a property right, otherwise known as monopoly rents? That is
known as what?
A monopoly rent. So
monopoly.
If a monopolist is overcharging consumers and regulation has the effect of removing the ability to overcharge, should the monopolist be compensated? And if so, for example, when the monopoly powers of Telecom New Zealand were removed and its market capitalisation fell by $3 billion, should that have been paid for by New Zealand consumers or taxpayers?
I don't see anything as stopping government from doing that. In fact, you can see good reasons why, if it thinks it's going to make the public better off, it will. Probably under the Commerce Act, what it's doing is declared as illegal anyway, so it probably doesn't have the right, the legal right to do it in the first place. The crucial question, the way the legislative guidelines put it in their checklist, is have vested rights been taken? And it's not clear to me it would be in that thing, but what I would say is there are lots of complexities in what is a liberty and what is the taking of a liberty then, who was free to do. What's the benchmark for determining what's a taking or what's a violation of a liberty? And there's a provision, and that applies to all the existing statements of these principles, which are already in the Cabinet Manual and the guidelines. They have to be interpreted. And the measure will, recognising that, will require the Ministry of Regulation, perhaps in conjunction with the Attorney General, to provide guidelines as to what the benchmark is for determining whether something's a taking or not. When you state a principle, it's usually quite general, like the principle "thou shalt not kill" is quite clearly, but clearly in wartime, it's kill or be killed. So people understand that principles aren't absolutes, but there are a lot of grey areas in when you come to apply the principles, and so it does need guidance. But I don't think there's a property right to have a monopoly position. Yeah.
All right, was there any other question now? Yes, we have.
A board. Could you say a little bit more about the board you talked about?
Okay. The board's got to have legal expertise in it because, as I've said, we're talking about what's the taking of someone's liberty and interference with one's liberty or with one's property. Well, what is their property in the first place? What do they really own? And what's liberty? So it's really essential that there's expertise in the board. The original task force proposal in 2009 was that the courts have got the expertise in these matters, they should adjudicate it. But that's all gone now. No one, sadly, trusts the New Zealand courts enough anymore to make that sort of determination. So the board is more of a concept like the Takeovers Board or the Waitangi Tribunal, a separate group of experts who can pontificate on things. And And if someone sort of puts an appeal to them, they can bring down their decision, and it's only going to get as much respect as the quality of their argument for that decision merits. And the politicians will respond as they want to. They might be completely dismissive because they know they've got the public with them, or they may think, oh, well, okay, we can move a bit on this one, doesn't really matter. That's what preserves parliamentary sovereignty. The information's got out there, the reasoning's gone out there, every parliamentarian can read it, all the general public can read it, but Parliament is still sovereign. What it does is its business. Hello, Jeff. Yeah.
Might make this the last question. We obviously have the opportunity near the end for...
Hi. Thanks. It doesn't have enough clout where it is. It's the Cabinet sort of instruction to itself, and if Cabinet does not comply, no one can do much. All you are doing by putting it into legislation is you're giving Parliament more clout and you're giving the public more information.
All right, thanks very much.
All right, so I just have one little question. So I was wondering, how are you here to help, and how are you going to help?
What's the question?
So what's the question? How are you going to help?
So how are you here to help, and how are you going to help?
Help with
Well,
what?
you
Sorry, I'm just here to help to try and explain the measure.
So how are you helping against, are we going against what's going in Parliament? Are you here to help us go against, or are you explaining what's happening? How are you helping?
The
can you
purpose of tonight is...
What's going in action, and what are we going against?
All right, well, the purpose of tonight is that there's now 2 more speakers who will adopt positions that...
All right, can you answer my question?
And at the end of that, there'll be the opportunity to then...
Can you answer my question? It's got nothing to do with my question.
So
what are you here for, and how are you helping?
Well, we're helping to inform. That's what...
Inform. So you're an informant?
Dr. Wilkinson, and now...
Okay, but what are we opposing? What are we actually opposing? So we're going against what bill? So obviously there's one statement here, the Red Tape Bill. What is it about? There's nothing what it's about.
No.
What is it about? What's happening that we're going against? Because what I'm hearing is a lot of blah, 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 a lot of deception. I've heard a lot of that bullshit. But what I want to hear is what's happening. Obviously, if you're here in a church, you're here at our church, and you're here standing with us or against us. You're telling us what's happening and trying to deceive us, or are you here standing with us? That's what I want to know
No,
about.
no, look, to be fair to Dr. Wilkinson, he is here to give a point of view.
Not just him, but you.
But we're about to, can I just say, we're about to hear two other points of view, and then at the
You
end
can't
of these
answer
two...
my question, none of them.
Well, we'll be better informed after the next two speakers. So if we can just hold off those questions until near the end. Thank you very much. Right, and to that end, now, you're obviously able to follow our speakers on the stage if they would like to exercise their right to wander. So there we go for our next speaker. Bryce Wilkinson was just asking. All right, Bryce Edwards, sorry. Now, Bryce is our next speaker. Bryce will be well known to many of us, and he's a director of the Integrity Institute, established as a campaigning and research organisation dedicated to strengthening New Zealand's democratic institutions through transparency and accountability. Bryce, I won't go through your impressive CV, but I'm sure your view will be well worth listening to. Welcome.
Thanks, Greg. Which one is best?
Well, actually,
I'll go with this.
try with that one.
Okay, kia ora, everyone. So yes, I really want to acknowledge Dr. Wilkinson's place here tonight, because I think it is really apt that we've got him. He really is someone that's been looking at these issues for decades, and I think, both at his time at the Business Roundtable and now the New Zealand Initiative, he has essentially written the Regulatory Standards Bill. He is the author of it and has no doubt spent, decades working on this. He understands it 1,000 times more than I do. I've spent a day looking at this, trying to understand it, and so take that into account. But I also want to acknowledge that a lot of the bill, I think, has merit. It tries to deal with some real things, which are sometimes over-regulation, sometimes very poor legislation that gets passed in Parliament. And so, I have a lot of respect for Dr. Wilkinson and for the New Zealand Initiative. They're, part of our debate, our national debate, and they put forward very quality and well-informed things like this piece of legislation and the reports that they help us with. But, of course, they're coming from a certain perspective. They're funded by corporations. And so, essentially, what I will try to argue tonight is that the Regulatory Standards Bill, the RSB, is something of an intended protection racket for vested interests. It's something that will improve the lot of business of the wealthy and will entrench the status quo with everything that comes with that, with the privilege, the inequality, a lot of bad things in society. And so for those of us that want to change the world and to combat inequality, social deprivation, climate change, all the other really big things that we need to deal with, dealing with the problems of the oligopolies in the banking sector, supermarkets, electricity, and lots of other sectors, we won't be able to do that if this bill passes, is the argument that I'm making. So, I guess I'm here today because I wrote a piece in the Post maybe a month or so ago, and so I thought I would just quickly go through some of the points that I was making in that, in case you haven't read it. And so I started this opinion piece off by saying, the Coalition Government has agreed to pass a regulatory standards bill proposed by the ACT Party, which will further tilt the playing field to advantage vested interests. Despite sounding rather dull, this legislation is potentially the most radical reform the Coalition will make this year, progressing an agenda to create a more pro-business environment in New Zealand. And so I then explained that it sounds quite boring, quite dull, and there hasn't been enough scrutiny of it. And that's partly because that's what the government wants. They have done some of the consultation over Christmas when no one's focused on it, but it's also, in my view, the fault of a lot of progressives in New Zealand. We've been out there sort of totally focused on the Treaty Principles Bill. This is the bill that isn't going to be passed. There's only going to be one party voting for it in Parliament later this year, whereas the RSB, it's going to be passed later this year. It's already got the commitment signed by National, New Zealand First and ACT. So it's actually something that if you're interested in how New Zealand is developing and who runs this country, who gets what, why we have some of the problems we have at the moment, we need to understand how this bill will make things worse. Okay, so essentially it goes hand in hand with David Seymour, who has set up the Ministry of Regulation, or what you might call the Ministry of Deregulation, because that's essentially the agenda that this bill is part of. It's part of a long line of market liberalisation that's been progressed through decades now to give business more power and to make the state less powerful and to disenfranchise and make, I think, the main part of society, workers, the poor, even the middle classes, less powerful. Okay, so the Regulatory Standards Bill, the RSB, sets up a progress to scrutinise each piece of new legislation in Parliament with the concern about property rights. So it tries to make sure that property rights aren't unfairly impacted, and in that way it stacks the deck in favour of business owners and the wealthy. So it sets up this new board, which is populated by the appointees of David Seymour, which can then go and look at pieces of legislation, looks at various rules, and tries to work out whether this is compliant with property rights. The argument against the bill is that it's going to constrain governments. It's going to mean that the public interest will no longer necessarily be the priority of those making laws. Instead, we will have more focus on compensating property rights owners if there's any change in policies. And so a big part of the RSB is this idea of compensation, which David Cunliffe was just talking about before, when property rights are affected by regulations. So the ACT Party says that whenever new regulations inhibit companies' profits, the property owners should be liable to receive a fair compensation from the taxpayer for this. So profits are protected, and if the governments want to make some changes around something like tobacco, alcohol, the rules of those things, if they end up impeding profits of the tobacco companies, the alcohol companies, then the taxpayers have to stump up the cash to make up for that. And that's why some people are criticising this. And so if we have to make changes in terms of climate change to lower emissions, and that impacts on some of the big businesses that are making the climate change, they have to be given compensation. And it's going to make governments much less likely to take those big, bold changes that will be needed to deal with things like climate change. So unlike the Treaty Principles Bill, this hasn't seemingly come out of nowhere. This bill has been brewing away for many decades. It's actually been introduced 3 times before by the ACT Party. This is its 4th time. So I guess I would see it as something of a zombie bill. It's been killed off, even by the National Party in the past, as being too extreme. But this time around, they've already got the agreement under their coalition agreement to get this passed. And so, in my view, it's in line with a lot of those reforms, especially in the late 80s and early 1990s, those neoliberal reforms under Roger Douglas and Ruth Richardson, that rebalance, an attempt to rebalance things in favour of business, restructure the economy against workers, against ordinary people, in favour of those that own business. And we've already seen over the decades what the response of that has been. It's led to more inequality, it's led to lots of market failures, things like Pike River, things like the financial companies needing to be bailed out, leaky homes. Sometimes we do need regulation. Sometimes the state does need to actually step in there. However, this piece of legislation is an attempt by ACT to continue that regulation process. Act have been thwarted, frustrated that deregulation hasn't gone further. This is their real attempt to make that happen. So in the future, I think it's going to make, if this passes, it's going to make the policy process even more one-sided than it already is in favour of vested interests. It will make lobbying much more powerful. Corporate lobbyists will have a much better way to appeal to this new board to get pieces of legislation deemed to be needing to be scrapped. So Simon Upton, the Parliamentary Commissioner for the Environment, has said that he thinks it's going to, if it's passed, it will end up producing a lot of poor legislation. And he draws attention to the fact that we don't have enough regulation around lobbying in New Zealand. And this is going to be a feast for lobbyists if it passes. We've had a few other interest groups that have critiqued it, but I'll just fast forward to the end to say that, if we want to deal with some of the big issues in society, where some people hold power and some people have privilege, and they want to protect their racket, if you like, this bill will do them very well, but it won't do the public interest very well. I think it's a Trojan horse. I think we have to take this much more seriously than some of the other pieces of reforms that are going through under this government at the moment. Okay, I'll leave it at that. Thanks.
We have got time for questions for Bryce. If there's anyone who wants to clarify anything or expand on or even comment on.
Or we can hear from Craig.
I'm curious. I presume that since business that gets a cost incurred upon it as a result of this bill will get compensated, businesses that can make a profit as a result of government policy will presumably have to pay an extra tax, because that's presumably the way it goes.
Yeah, that's true.
So suppliers of scaffolding will presumably have to make large payments on the basis that their business has benefited from health and safety regulations. Is that provision in the bill?
Well, just to be clear, and as Bryce has already pointed out, the bill hasn't actually been written. We've seen different versions of it over the years, and the ministry has put forward a document about what might be in the bill, and it's up for the politicians to actually put forward a bill in the next few months. So I'm not sure if that sort of detail will be in it at all. So we're all a bit in the dark on it, which is rather unfortunate, I think.
All right. Thank you, Bryce. And we'll now, and just for our speaker there, this is the whole idea now, is this is a debate, so there'll be different views, and we'll condense them at the end, and hopefully people will come away with a good idea of what the legislation is about and where they will stand on it. Our third speaker, Craig Renney, economist and director for policy for the New Zealand Council of Trade Unions. Before that, Craig has been working as a senior advisor to Deputy Prime Minister and Finance Minister Grant Robertson, and also worked with Prime Minister Jacinda Ardern. Also has a background in the Reserve Bank, Treasury, and the Ministry for Business, Innovation and Employment, MB. So, Craig, welcome.
Thank you. Tēnā koutou katoa, ko Craig Renney aho. As advertised, I'm Craig Renney, the Council of Trade Unions Te Kawe Kaimahi's economist and Director of Policy. It's a pleasure to be invited to talk with you tonight. Before I start, can I thank the organisers of this event for giving me the opportunity to speak with you this evening and for organising such a timely event. And can I thank Dr. Bryce and Dr. Bryce for their thoughtful contributions to this programme. It's not often I'm brought in as the diversity hire, but as the only non-Dr. Bryce speaking with you this evening, it's nice at least able to bring a fresh name to the conversation, even if my surname is always misspelt. Now, as you know, you're in Wellington when a red tape Hui fills a room. But the Regulatory Standards Bill is on which we're talking about this evening is definitely worth discussing. Now, if you haven't seen this document, I recommend you go and have a look on the website. It's got lots of questions inside, but there are some big claims made in this publication. The very first line of the Minister's foreword says, and I quote, "Most of New Zealand's problems can be traced to poor productivity, and poor productivity can be traced to poor regulations." Really? Climate change, earthquakes, persistent underinvestment, excess profiteering, the poor form of Wellington Phoenix, bruised avocados, regulations? Regulation clearly has an important role to play in all of these things, but to suggest that all of our problems stem from poor regulations is to misunderstand our problems to the point of satire. Instead, I'm going to argue this evening that most of New Zealand's problems come not from poor regulations, but they actually come from poor choices. Poor choices that have consistently let down New Zealanders. Poor choices, unfortunately, are at the heart of this proposed reform. So let's start with something that's really important to the trade union movement: health and safety. Are poor regulations holding back our performance on health and safety? We are, after all, a country that still kills 17 workers a week as a consequence of their work. That's a little under every 10 hours we kill a worker in New Zealand. Every 15 minutes, we injure a worker at work so badly they've got to spend a week away from work. By the time we finish tonight, 8 workers will have been injured so badly they have to spend a week away from work. We have a fatality rate 5 times that of the UK for work, or twice the rate of Australia. Is the problem in health and safety our regulations? Much of our regulations in health and safety actually just mirror the UK's health and safety regulations or the Australian regulations. A possible exception here would be engineered stone, which is a product that's still sadly killing the workers who have to live with it. In Australia, it's banned, and here, an ACT minister is considering tinkering with the standards. Is the problem here the regulation or the choice of minister? Choices by the minister. It's not the regulation, then could it be the enforcement? In December last year, Workforce, the body that looks after health and safety, announced to be cutting 54 rules. That's 54 rules on top of the 113 rules it lost the year before. Can you tell me again how the Regulatory Standards Bill, regardless of how well it's written, can be of any practical purpose if the organisations designed to enforce it are being so enfeebled? Let's take another example. In the good law section of the consultation paper, it states that legislation should be expected to produce benefits that exceed the costs of the legislation to the public or persons. Much to the great annoyance of economists like me, public policy is often not reducible to definitive calculations of costs or benefits. The costs and benefits of a given regulation are often unequally experienced, and whether the policy is considered beneficial is often in the eye of the beholder. Let's take, for example, a regulation that says an employer may strongly approve of regulations that prohibit strikes by workers, but may strongly disapprove of minimum wage regulations. On the flip side, trade unions and those who work for a living may strongly approve of regulations that allow strikes and strongly approve of regulations that guarantee a minimum wage. How are we to truly make a neutral calculus, according to a Regulatory Standards Bill, of that? And how much work should the word expected in that statement be doing? Expected by whom? Expected by when? Expected what? Another example here is social welfare transfers or benefits. If we were all to be good economists, we'd all be narrowly viewing the direct financial costs of transfer payments as being borne by taxpayers, of which higher income taxpayers would contribute a disproportionately larger share. They should be able to see a disproportionately larger benefit. But any rational analysis of welfare would also look at the larger social benefits which accrue to everyone, such as minimizing the many social and economic harms caused by abject poverty. And judging whether or not benefits to welfare recipients in wider society exceed the costs to taxpayers is a political question. Again, it's not a regulation question. Moral judgments on justice and liberty and the trade-offs between them are inevitable in politics and inevitable in regulation setting, how would this bill view the winter energy payment and the fact that we gave it to everyone? So it's not merely a technical question of good lawmaking. To me, for example, there's no safe level of child poverty in Aotearoa. It's corrosive to all that's good, but others might disagree. But these are moral points of judgments, not cost-benefit analyses. So let's look at another area of the consultation paper, and Bryce touched on it just very briefly. Legislation should not take or impair or authorise the taking or impairing of property without the consent of the owner unless fair compensation for the taking or impairment is provided to the owner. That's a very long sentence, forgive me. Okay, how would we have played this out when we created plain tobacco packaging? Should we have paid Philip Morris or Imperial Tobacco compensation for banning their advertising as a part of their packaging? For banning the advertising of a product that kills 5,000 New Zealanders every year? Should it be a net figure? Should we only pay them after we've taken our costs for looking after all the people who die as a consequence of tobacco on the other side? Should Philip Morris or Imperial Tobacco have paid us back when this government stopped the smoke-free Aotearoa programme? It makes no sense. The legislation will simply be used as a means of scaring governments away from making important and necessary decisions for fear of financial loss and for fear of being sued and for fear of being dragged through the courts. Now, the Regulatory Standards Bill also says that legislation should continue to be the most effective, efficient and proportionate response to the issue concerned that is available. Now, for most policy purposes, there's reasonable disagreement about what effective, efficient and proportionate is. Different solutions will have different advantages, and we'll have to trade these things off. Trying to find a blanket provision that works is simply not feasible. Additionally, if we're to take that point seriously, then shouldn't the first piece of legislation that be tested against be the Regulatory Standards Bill? Because the Regulatory Standards Bill, in the Regulatory Impact Statement, says that we shouldn't be doing it. It's not the most efficient or effective means of delivering that particular end. In fact, the Ministry of Regulation said, please don't do the Regulatory Standards Bill. The Ministry of Regulation's own advice says it advises against the proposed bill in part because of the high compliance burden it would create, something which makes it inefficient, their language. So let's call this what it is. The Regulatory Standards Bill is little more than an attempt to skew the pitch for years for governments to come. The principles of the bill are overly simplistic and biased towards a particular ideological view, one that has led to multiple costly regulatory failures in New Zealand. Deregulation, often in the past 30 years, has cost more than it's gained. Regulatory quality is important, but that requires consensus between political parties and adequate resourcing in order for it to be effective. This is the opposite of what this government is proposing. What is being proposed is a heavy-handed system that will hamper actually adaptable regulation. Now, the minister's claim that he's presented as his primary rationale is simply not true. New Zealand has many problems that are not just economic, and there are many factors other than regulation that affect productivity. The economist Paul Krugman wrote recently that measured productivity isn't the only thing that matters. What, after all, is the economy for? The goal is to improve people's lives. That is often achieved by increasing gross domestic product, but it's also improved by having clean air and not by injuring workers. It's not a trade-off we want to make. This bill asks us to make that trade-off. The CTU does not object to improving the quality of regulation, and it's a perfectly honourable and reasonable thing to want. And I don't disagree with people who've been working on it in years. It's a perfectly reasonable place to be. But the proposed bill, like the many versions of it that have come before, is simply designed to reduce the quantum and reach of regulation in New Zealand, based upon the rather crude idea that less regulation leads to better economic outcomes. Now, anyone who's ever heard of the word weather-tight knows that not to be true. It seeks to embed an inappropriate set of libertarian political beliefs as standards of good lawmaking, and that's fundamentally undemocratic. Finally, because it will be appointed by the sponsoring minister who's publicly stated deregulatory biases, the proposed Regulatory Standards Board, madam, who will oversee the Act, can be expected to function as a partisan tool against any government that comes in later. Let's start with it again. Most of New Zealand's problems can be traced to poor productivity, and poor productivity can be traced to poor regulations. We know that instead, that most of the problems facing workers and their families across Aotearoa are the consequence of actually poor choices. The choice to gut the school food programme, the choice to give landlords $3 billion in tax cuts, the choice to stop state house building, the choice to force Te Whatu Ora just this year to save $2 billion, the choice to cut the minimum wage in real terms for 2 years in a row, and to steal the living wage from those who still have it. The choice to waste millions of dollars on the Treaty Principles Bill. Our regulatory standards won't solve any of those problems, and the Regulatory Standards Bill certainly won't. It's only when this country makes a different choice, possibly in about 582 days' time, that we'll see real change that will deliver on those programs. Thank you. Stunned and silent.
All right, well, what we intend to do now... Oh, sorry, the hand did go up here.
Oh dear, I'm in trouble.
The principle of a wealth tax?
I think we'll have to wait to see the actual content of the bill first, is the honest answer, because we'll have to wait and see how it's actually going to be expressed. I think one of the things you're raising quite importantly is that the bill, if it's written in a particular way, would stop Parliament from doing many things, or may well act as a real barrier to Parliament acting, not just on a wealth tax, but on many different areas. We've talked about climate change, and I think that's very fair. Labour regulations, there's a reasonable case in which actually a firm may well take the Crown to court by saying, well, you've ruined my business model, because my business model was predicated upon me being able to do this to an employee. I now no longer can. Give me cash. So I think we're going to have to wait to see what the bill actually contains, and that's the fairest thing I can say right now, but it's a risk to a wealth tax or to many other forms of regulation that many people might think of as being beneficial, or at least political parties in Parliament might think of as being beneficial. Oh, I'm definitely in trouble.
Just a question. When you're saying that this would open government up to, various kinds of lawsuits and sort of claims from businesses and so on and so forth, obviously, as Dr. Wilkinson has said, it's all likely to be stuff that's advisory, not sort of binding on government as such. Do you still see a way, though, that it would actually open up government to legal challenge? Because, notionally, a government could ignore the advice of the Regulatory Standards Board and just say, we're doing it. So where would the opening be for those kinds of objections from firms, do you think?
Can I just say now, we're sort of now morphing into a general discussion. So what I'll invite is Bryce, if you would like to answer any of these questions now, any view on any of the questions that come to the floor. So we'll just now morph into our general discussion on this, because I'm sure that there'll be, Bryce, you'd probably quite like to have a say on that last question as well.
What was the question? My hearing is not very good.
Oh, so we can get the question repeated if you like.
Yeah, if you do the questions for me, thanks. Yeah, because I'm finding it's reverberating in my hearing aids, and I'm not getting it.
It is a little bit the same. Yeah. Maybe we can move forward even. So,
look, if I can briefly repeat the question, and hopefully you'll be able to hear Dr. Wilkinson. Is this clearer?
Yeah, that's me. Yeah.
My question was, what would the opportunities be for firms to sue government over laws that might be deemed inconsistent with the bill if the board that it creates is merely advisory? Would there be opportunities for firms to make claims against government and thus delay laws in the ways that Mr. Renney was suggesting?
Yeah, we haven't seen the details yet of what's proposed for the board, but my presumption at this point would be that anyone can appeal to the board. My presumption is that the board is open to the general public, so that if anyone thinks that a minister's made a false declaration to Parliament about inconsistency or consistency, the discipline is the member of the public's got some redress. So instead of going to the court for a declaration, as was proposed back in 2009 and 2011, they go to the board. So sure, people will go to the board if they think the minister's made a false declaration, and they'll want to use the board as ammunition, and the board's opinion will go to Parliament, so it will give the parliamentary opposition something they can quote. And as long as we've got a good board, it should be reputable, and it should give good reasons for its decision, not patently false, politically biased reasons. So as long as we've got a board of quality and it makes decisions which people can read and think, yeah, that's logical, I can see where they're coming from, it's consistent with what they've been told to do, then it should have some clout in the public and parliamentary debate. But that won't happen right away. And it'll be contested immediately because people who think the minister made the right decision, and including the minister themselves, are immediately going to go and contest something which the board's put. So it is just a transparency measure, but as long as it's got real expertise and it's not politically biased, it should be useful for public debate.
Just I wonder if you a minister making a false statement or
something which someone disagrees with.
Can you think of an example where a minister might say something that would require it to go to the board? Perhaps might give some good context for what we're talking about.
No, I think someone's got to take it to the board, or maybe the board will have a terms of reference where it can initiate its own decision. That would be pretty. That would get pretty political. That could be dangerous. Well, as David Cunliffe sort of question to me earlier went on, there are lots of issues which are in the grey area. Is it a taking or isn't it? What was the right in the first place? Now, what's going to be required is the minister, let's say they say it's inconsistent, but I'm going to go ahead and do it anyway for this reason. That's option one. I don't know whether someone will be able to go to the board and say that's not a good enough reason. I suspect not. But I suspect that if they've acknowledged it's inconsistent but said it's going ahead anyway, that's fine. The board can do nothing because it's already been said it's been inconsistent. If it goes the other way and the minister said, well, this is a grey area thing, but I believe what we're doing is consistent, and someone feels affronted and wants to challenge that, then my understanding of it is they'll go to the board and the board will have to wrestle with the problem and come out with its verdict. I don't know. I presume in some cases, in the really grey ones, that will have to say, well, on the one hand this, on the other hand that, rather than try and make an arbitrary decision. So it's a complicated and technical thing, really, and a lot of it will depend on the professionalism and quality of the argumentation.
May we please have Craig Renney's response to the question, because the issue was addressed to him initially. Thank you.
That's right. I think I've got a mic on. Right. Thank you. I think, Max, the question you were asking was about how is it that essentially an individual or an organisation or a firm can sue the Crown for loss. and if I'm looking at it, I'm having to put my glasses on, so forgive me. In the consultation, it says legislation should not impair or authorise the taking or impairing of property without the consent of the owner unless fair compensation for the taking or impairment is provided to the owner. So if an individual or an organisation or a company says, you have impaired my goodwill, you have impaired my intellectual property, your regulations have stopped my business method, they can apply either directly to the minister or to the court or to the board to say, on this basis, I have not been given fair compensation. Now, there will then be a calculation of what fair compensation is, and I'm sure me learned friends will be making large amounts of money both ways in order to work out what fair compensation is. But it is a principle in there that essentially you cannot do something that impairs or removes someone's property without compensation. Even if there is a fantastically good public policy purpose to that end. And that's really a slippery slope and a real risk, because there are plenty of things that we might want to do. And if I look around the world at trade deals, for example, lots of countries get into trade deals with things called ISDS clauses, or interstate dispute clauses, where if the government changes the law in one area, other countries' firms can sue that country for the potential loss of profit as a consequence. And this is a very similar kind of clause. And that's what worries me, is that it creates just even the fear of it impairs the delivery of good regulation and impairs the delivery of good legislation in a country.
Yes, and while you do, one thing that did occur to me is that we're almost talking about an upper house here, aren't we? This board could actually, as it's described, New Zealand is a unicameral parliament, and we're actually, are we now with a board like this? Are we? No, it's non-binding. Non-binding.
Yeah, it's got no cloud at all. It's like
you might just speak into the.
No cloud at all. It just gives an opinion. Like a Royal Commission. We have Royal Commissions quite often. They come down with a bunch of conclusions and recommendations. Parliament can just, and has in the past, just ignored them. So its contribution is to public debate, and how good that is depends on how professional it's going to be and what it says and its reasons for it. But it's non-binding. Someone's aggrieved. I think the minister's made a false statement. They go to the board in the hope of getting confirmation of that, which then will lead to public debate. It only changes what Parliament. And on Craig's worry, this compensation principle and the presumption of favour of property rights is already in the Cabinet manual. It should be having an effect, but it's not absolute. So Parliament can do what it wants as long as it makes clear that there's no compensation. Now, these international agreements might be different, but they apply whether this regulatory standards bill exists or not. So it is an issue. Are we going to have to? I'm not a lawyer. I don't know. I don't know if the New Zealand government. It'd be hard to do, wouldn't it? You've entered an international treaty with someone, a common thing, you've got a compensation clause. You can see it's a bit hard for a government of the day to say, well, we signed that thing we've signed, but, go away. We're not going to do that. But that's sort of like saying, well, that agreement, that treaty is no longer valid. We violate. If you walk away from one part of it, you've walked away from a lot, haven't you? You can't pick and choose. If you sign something, you can't pick and choose afterwards just what parts of it you're going to agree to. Yeah, well, that's true. We're looking at one right now overseas, aren't we? Yeah.
Thank you, everyone. I'm really interested in It's on. Hello, is that working?
Yeah.
Okay. In the interests of transparency, what happens now I mean, it's not a bill yet.
No, we haven't even seen it
and
yet.
What is the process, and what's the process if we object to what's actually happening in this whole process?
Yeah, I can answer that. Yeah, so we've had the discussion paper, public have given feedback on it. Now the ministry compiles all that feedback, gives it to the minister. The minister takes, which is David Seymour, a cabinet paper to cabinet, and that's a and hopefully that will have a draft bill in it. And Cabinet will be able to see what's been proposed. It will deliberate on that, and David Seymour's only one voice in Cabinet, but they do have an agreement to pass something called the Regulator Standards Bill. But the details are a bit in flux because of the debate and no longer having recourse of appeal to a court. So anyway, it goes to Cabinet, Cabinet makes the decision, and then it goes through the process. When a bill gets taken to Parliament, the first vote is the first reading. Will it proceed? If it proceeds, it goes to a select committee. The select committee opens it up for public consultation, and it gets the feedback. Then there's a second reading, and the usual process follows.
Craig, if the bill is already in Parliament, I mean, how have ACT and National and New Zealand First voted? How is that? I just not understand that process.
Variations on a theme of this bill have been in I think 3-4 times. Three times in the past, with slight variations on what's being proposed. As Dr. Bryce said quite rightly, this is pre-consultation. So the ministry is working out what it wants to put inside its advice to the minister, and that consultation is what we've seen to date. Now, I'll not lie to you, I'll be astonished if what's in here doesn't actually end up in the bill. Because generally speaking, you don't write things down and consult with the public with them if you just fancy working out, saying, is it going to land? You're actually working out, where is the weight of opposition? So you can help the minister work out, actually, people don't really care about this bit, but they super care about this bit. Perhaps you want to concentrate on that. So I'll be astonished if that doesn't get carried forward. I don't imagine this will be carried forward as part of budget night legislation. It's too important to go through budget night legislation. So there'll be a full parliamentary process. Be first reading, select committee, second reading, committee of the whole, third reading, and then leg. Please.
Sorry, thanks. I mean, it's interesting that this legislation was introduced into the House when 80,000 people protested in the Hikoi to Parliament. I thought that was very timely, and it's something that nobody's mentioned tonight. I think it is a really significant point.
I think it's a case of these are bills that have been put forward by ACT, and they have a very particular ideological worldview. And they tend to be, or have tended to be, more divisive than other bills in the House. I hope that doesn't continue, is the honest answer. But in terms of this particular bill, we're still a bit early in the phrase of actually being able to see the black letter law and being able to see what the Parliamentary Council Office, who the people who actually write the law, come back to us with. There's still a bit of way to go before we get there, which actually means we may well be seeing this bill being passed, if it is passed, right at the end of this Parliament.
What was the agreement in the coalition agreement around this? How much detail was there in that as to what will be in the bill, or do we not know?
No detail. It was that the Regulatory Standards Bill will be passed.
That's simply the agreement, part of the agreement.
Yeah,
so.
that's and the crucial word there is the definite article, but it's the bill no one is supporting now in terms of the appeal to the courts. So it's no longer quite the bill. So there's more opportunity for debate and modification. And the replacement by a board is part of that. There's a lot of detail to be gone through as to the terms of reference of the board, the power, the composition, what resources it'll have to have, how many complaints is it going to get. Yeah, it's a lot of detail.
The only thing I'd say, Greg, is that coalition agreements can be mercurial things. Having had the fortune of dealing with two in government in 2017, they can be open to interpretation at different points in time, and changing context can apply changing lights to those particular coalition agreements. So, words on a piece of paper at one point in time mean one thing, but the passage of time may force a different interpretation later on.
Yeah, very true. Yeah, and you've lived through it.
I've lived through that. Yeah. So I don't think it's there is a simple line in there about the Regulatory Standards Bill, but it hides a multitude of sins in terms of actually how we'll actually get there.
Yeah. We'll just compare that with the Treaty Principles Bill, which is again part of the coalition agreement. How detailed was that?
Well, that's really interesting because the Treaty Principles Bill says that the government will support two select committee, is the exact words, the Treaty Principles Bill, not second reading. So it can support it to the select committee, but then the first day of select committee, the National Party and NZ First MPs could have said, kill it, send it back. We don't need to spend any time talking about it, no money, nothing, on the first day of select committee, and they didn't. They voted to actually keep the select committee process going. So everything after that was a choice by this government to do that, and a choice to spend all that money and all that time to do that. They didn't say take it to second reading, which is where it's heading. Instead, they said take it to select committee. And I'll be really interested to see where the committee ends up on its actual recommendations to Parliament on that basis and what it suggests doing next. They're
just preparing their report back as we say today. I was in that select committee. Yes,
I'm interested in the change in the wording from the 2021 Private Members Bill, which proposed that the courts would have the right to issue declaratory judgments about the matters in hand to a board. And I'm wondering, did the ACT Party see a Trojan horse in that? Did they see that judicial activism might actually lead to the reverse of what they wanted?
Yes, very unpredictable, and officials were pointing that out. Yeah, it wasn't just ACT, it's deeply across the public service, lack of confidence in what the courts will do anymore. It's sad. It's serious. It's a much more serious problem than the bill, which, as I stand by my view, it's a weak measure.
Donald Trump's having the same problem at the moment.
Is he? Yeah.
Courts.
Yes, he's going to have bigger and bigger trouble, yeah. But we support the courts.
I think the question might be, who should the public have trust in long term? Right? Do we have trust in the long term in an independent judiciary, or do we have trust in the long term in politicians? I think the honest answer is both are unreliable partners at times. But you need very clear separation of powers, and you need very clear separation of rules in order to try and deliver at least the least worst system here. The proposal in the previous bill, I think brought in things that wouldn't do that.
Just wanted to say I would like to hear from all the panel about the implications for health and safety, because it's been my big worry that health and safety might be weakened by this bill. So I'd like to hear from all of the panel, especially the one who haven't heard from much.
I think that's you, Bryce. Go on,
you haven't said anything yet.
Thanks. Yes, I think that is an apt question, and Craig has already taken us through how this might have a nexus with health and safety because health and safety is often a cost to business. The more rigorous and robust the regulations, the more profits sometimes are impeded, and so there could be an interpretation. If there's improved health and safety legislation that protects workers, it could be interpreted as taking something off business, and therefore we might see governments avoiding having more robust health and safety legislation because of that. But as we've really talked about in the last 10 minutes, the devil is going to be in the detail with this bill. It's just too hard at this stage to predict exactly what's going to happen. And so, and I still suspect that New Zealand First could still stymie what ACT's intentions are with this bill. There could still be a pushback from New Zealand First, especially after St.Peters is no longer Deputy Prime Minister. He might not be so keen on that line in the coalition agreement saying that they essentially have to back this bill.
Could I just say that I would expect productivity would be seriously impaired when there are serious accidents and the whole industry or factory or wharf might have to stop for some time while it's dealt with. So I should think that health and safety properly observed doubtless can help productivity.
Sing it, sister. I think you're absolutely right. I don't think we know the exact I don't think we know the exact end point here. We clearly haven't seen the bill, yeah. But we can trust the direction of travel, right? And it's quite clear the bill has been written or at least the consultation has been written in such a way that it's going to make the delivery of effective health and safety legislation harder. It's going to make the delivery of effective health and safety legislation, especially where it costs employers something to deliver, much harder. And so I think there's a real risk that, for perfectly good reasons, we want effective legislation, we want effective regulation, we want it to be as light touch as actually as possible, it actually helps. But for all the right reasons, we'll get all the wrong outcomes. That's a real challenge for us.
Perhaps we can talk an example there. Compulsory roll bars on four-wheel drive motorcycles. Now, that might be, how might that work? Because that's something that it's being resisted at the moment. So how, if that was made compulsory by government, and it's, how might that work under this proposed legislation? Who would need to be compensated?
I don't know if anyone would. Is there any taking of a property right there?
There's nothing to take in that sense. The only thing that would be that the acquisition of your roll bars would then be taxable as a deduction. But in terms of there's nothing taken as part of that. But if for example, you say a product which is part of an essential production line is now illegal, it's unhealthy, it's immoral, it does something else, we just don't want it as a product. It pollutes the environment. Taking that away would then allow an employer or a firm to say, hang on a second, I have to use a more expensive substitute. I want to be compensated for the use of that more expensive substitute. Or I've lost customers as a consequence of the banning of that product. You're going to compensate me for the loss of those customers. Or I'm going to lose profit over the next 5, 10, 15 years, whatever period. You're going to compensate me for the difference between the two. The reality is, a bit like PPP projects, we're all going to end up in court. And we're all going to end up in court for a really long time to work out what these things are.
All right, look, we're coming near the end. We've got time for maybe a couple more quick questions. We promised we'd be out of here by 7. So, yes, one question here.
Thank you. Just a question, and hopefully Dr. Wilkinson can hear, a question about what is going to count as a property right, in all probability under this bill, with the caveat that we haven't seen it yet. I think if the state takes your home in order to put a motorway through it, broadly speaking, everyone would agree that that's something for which you should be compensated.
Yeah.
Conversely, David Cunliffe asked about what happens if you get your monopoly rents taken away from you, and I think most people would say that's not something for which you should be compensated, although I noticed you gave a slightly equivocal answer on that. But what about this question of profits? Are companies' expected profits property rights for which they should be compensated, for which they are likely to have to be compensated in the view of the Regulatory Standards Board? I mean, Dr. Wilkinson, do you think that that is what should happen? Because as others have pointed out, almost everything government does affects companies' profits in one way or another.
Yeah.
So if that were the standard, almost everything that government seeks to do could be ruled out of bounds by this board, albeit it wouldn't have any particular force. That seems to me potentially unworkable. But is it your view that expected profits are a property right for which compensation should be paid if they're affected by government?
No, absolutely not. Take the example in the 1980s of the deregulation of taxis. Taxi licenses were selling, I gather, for about $70,000. So if you wanted to be a taxi driver, you had to get a license. And that wasn't a government-imposed levy, that was just what the market clearing price was. When the government deregulated the taxi drivers, the price went to zero. Someone who had paid their $70,000, had their car, now had lost $70,000. Should there be a government taking for that? The view amongst the lawyers I was talking to was no. No government ever said to them that this is what you should pay for a taxi driver licence. No government ever said to them that we're never going to issue any more licences, so you've got guaranteed security. It was purely a buyer beware thing. And the same with import licensing, that was allowing people to sell goods at 2 or 3 times the imported price. But when import licensing was relaxed, there was no issue of compensation for that. Let me give you another one though, where I think there is a case, and that was there was one firm in New Zealand, I think, was farming shrimp. And then the government passed a law that, sure, you can farm shrimp, it might not have been shrimp, but you're not allowed to sell it, no retail selling. So that was the end of their business. Presumably this was done for someone else's benefit. It certainly wasn't done for the benefit of the people who had invested the capital in it. So presumably a judgment was made that the benefits to these other people exceeded the cost, but they'd invested in their business. A law destroyed it. A similar one would be if you're a farmer and someone designates the bulk of your farm as a special natural area or something, and you're no longer allowed to use it as a farm. Presumably that's done for the benefit of people who want to see it as a natural area. So if the benefits exceed the cost to those people, well then the farmer doesn't have to be made worse off. I mean, they're obviously quite innocent. They bought the property, then they get a designation on it. So these issues need to be worked through, and there are a lot of variants on it. If you want to read about it, Richard Epstein's written a famous book on takings, and there's lots of complexities to it, which is why this board really needs to have real legal expertise. Property law is a big, complicated law.
If I may just very briefly on that, I think what is property? Anything that has value is property. And we asked, would future profits be part of the consideration of that property? Future profits are baked into the value of a property, particularly where it is commercial. So if you say, I'm going to reduce the profits of our factory by 10, 15, 20%, you reduce the value of that factory. And as a consequence, the value loss essentially is the future cash flow and the profits foregone. So it's incorporated into the loss of value, and that's how you end up paying for it regardless. So I think it's there in there, and I think that's what essentially you're paying for if you are compensating someone for the loss of something as a consequence of a regulation or a piece of legislation that you've passed that has inhibited their ability to make profit from where they are now.
All right, we've just got time for one more question here. A very patient lady down here.
I think it may have already been partly answered. Is there any indication that such compensation would be just a one-off, or could they come back and back and back in the future for future compensation because of the same legislation?
No, it's just, if it's one incident, it's just one-off.
It would depend if there was anything new or material that had changed. So if normally it's one-off. I totally agree with Dr. Bryce. However, if there is a new piece of information that is material to the actual value of the piece or to the payment that should have been known or could have been known or was not disclosed or which is genuinely new, then that probably would give rise to a change in compensations paid. And around the rest of the world, for example, personal injury compensation, you may receive a one-off payment, but if knowledge changes about how that is going to affect you for the rest of your life, or you receive some form of treatment that changes how you can be impacted by that disease or that issue, it changes the compensation. And so it might be different depending upon if it's material or not.
I think two things need to be said. One is there's no compensation if the government makes it clear, which is the existing. And the other one is related, is that this principle has already been there in the Cabinet Manual, including the principle that compensation should be addressed. So the same thing will continue. If Parliament is in danger of getting a court case to pay compensation and it decides it doesn't want to, all it's got to do is make it clear. End of story.
All right, look, I presume there'll be time to, I don't know if our speakers are going to be able to hang around for a few more minutes for a little bit of a chat, but I promised Gail would be all finished by 7, and we're at that slightly past the witching hour now, Gail. So, look, I'd thank our speakers. It's a shame that the whole of the country doesn't get to hear such informed debate, because I know you've all come in here and will have all learnt a lot. And I suppose it's just what we're so short of, but congratulations for tonight, for having this opportunity. I know there's quite a big online presence tonight as well. So we all go away a little bit better informed. And this is a sort of respectful debate, which sadly is lacking in New Zealand. I must say that having sat and watched debates in the House where a lot of urgent legislation went through, where the only rationale for some speakers was it was in the coalition agreement. When I went into Parliament, I always thought, I had a lot to do with parliaments around the world. I always thought we were lucky we had a unicameral system. After 6 years there, I've changed my mind. I think we need an upper house. So, although I shouldn't be injecting myself as the MC, but perhaps this is the level of debate we probably could have.
Thanks, Bryce.
So
thanks,
can we have
really good.
And I believe we're finishing off with a karakia. Are we?
Okay.
I'd just like to give a small gift to each of our speakers who've generously come here this evening to inform us. The most important thing, if I can just say one word, is that this is a process, and we have the bill will be available to be our first reading and then public comments, etc. And this is just testing the waters for you on how important it is for you to take the democracy to heart and undertake submissions and critiquing of this particular bill. Thank you.
Thank you very much.
So while Gail is finding the correct cards for the correct people, we might bring our thoughts and our longings and our commitments into the presence of the Holy. Loving God, we've heard much tonight. Some of it has been tricky to get our heads around. Some of it has fired us up. Some of it has made us sad. Some of it has frustrated us. And we ask that your Spirit enlivens us to do what we can do to bring justice in our communities. So may the God of compassion fill our hearts with courage and hope, so that we may be faithful to the way of love and the power and strength of the Holy One. Mā te atua o te aroha, e whakau o tātou ngākau ki te maia me te tūmanako, kia pono ai tātou ki te aro o te aroha. I rungi te ihi, i te mana o te wairua a te atua. Kia tau ki a koutou, te atawhai me te manakitanga o te atua kaharawa. A te matua a te tama a te wairua tapu. The blessing of God creating, redeeming and bringing life be with you now and remain with you always. Amen. Eat some more bread.